Welcome to the Texas Probate Real Estate Podcast. Here on this podcast, we cover interesting topics that are relevant to executors and administrators that are handling probate estates and especially handling real estate in probate estates. My name is Jeremy Kritt. I'm the owner and broker of Kritt Real Estate based here in Austin, Texas. We do business all over Central Texas, including San Antonio. And I am joined today with a wonderful guest, Eric Grogan, who is an attorney based here in Austin, Texas, but does business all throughout Central Texas. Before I introduce our guest today, I just want to share why I asked Eric to come on. I was on Facebook, Eric, and Eric is right here with me here. I was on Facebook very late at night because I don't sleep very much, Eric. And I was just kind of, flipping through Facebook, and Facebook is confused about who I am. The algorithm is confused about who I am. The reason why it's confused is because I specialize in helping probate executors and administrators with real estate. Now, I'm not an attorney, but Facebook sometimes it thinks I'm an attorney because I'm always looking up legal stuff and I'm always looking up probate stuff. So it thinks I'm an attorney. So when I'm going on Facebook, I'm getting kind of one of two things. I'm getting people trying to sell me stuff to become a better realtor. And then I get a bunch of marketers trying to sell things to attorneys. So as I was going through that, Eric came up and it was an ad that Eric had. And it was very successful because it got my attention. And it's because Eric has a very interesting, unique model and approach and mindset. And it was something that I personally resonated with because as a real estate broker, I spend a lot of my time going to people's houses, sitting at their kitchen table, belly to belly, and hearing about a problem or a need that they have, and then seeing how I can bring my skill, my experience to help them. And I just really loved Eric's down to earth, very earthy, very human approach to the practice of law. And I said, I just started this podcast. And I said, you know what? I want Eric to come on here because I feel like Eric's my people. So I was like, and Eric was very gracious. You know what? Eric was exactly how he portrayed himself to be in the ad. He portrays himself in the ad to be very nice and down to earth and relatable. And when I called him, that's exactly what he was. He was just like, yeah, very easy to talk to. It was great. Eric, I want to welcome you to the Texas Probate Real Estate Podcast. Thank you for coming.
It is a pleasure to join you. Thank you so much for having me.
I want you to share with us your journey into the legal profession, how you got into your practice area. Tell us a little bit about before and then kind of where you are now.
Sure. I have a very unorthodox practice, which I think you highlighted quite nicely in your introduction. As you can tell behind me, I have all of my certificates, diplomas, all that stuff, but I've been playing guitar for 30 years and I don't have a place to store my guitar amplifiers other than right behind me in my office. So please excuse my background. Before I was an attorney, I went to college at 29 and I went to law school at 33. So I was one of those people, and I'm sure there's quite a few people out there as well that didn't know what they wanted to be when they grew up. I was in plumbing initially out of high school. I waited tables. I tended bar. Ultimately, I was a personal trainer for more than a decade. I put myself through St. Edward's and through the University of Texas School of Law, working at Gold's Gym and Bee Cave. So I was one of those people that was moonlighting at work and going to school during the day. I didn't get into estate planning and probate immediately after law school. I was initially doing insurance litigation in Dallas after I graduated from law school, and I kind of fell backwards, just happenstance, into estate planning and into probate, and it just turned out to be a much better fit for who I am as a person and who I wanted to be as a lawyer. My practice, again, is very unconventional. I make house visits for people. I don't know many attorneys who do that, whether it's in the probate or estate planning sphere or really in any other practice. And my clients love it. For me, honestly, it's the best part of my day. It gets me out of my office. I get to meet people in their space. People are much more comfortable when you come to them and meet them in their space than they are coming to a cold legal office just north of Austin. So for me, that's really helped to build trust between attorney and client. One of the most important things for me is just being able to communicate and having that open line of communication between lawyer and client. I regularly update my clients. I try to be as accessible and as responsive as I possibly can be, and it's turned out to work pretty well. I've been doing probate and estate planning here in Travis County as well as Williamson. I do some in Hayes and occasionally in other counties now for quite some time. So I've figured out how to navigate different courts in different areas. But the best part of my job at the end of the day is just honestly helping somebody. This is a complicated, convoluted, confusing process for almost everybody. And that's where the guidance is needed and the guidance is appreciated. So that has really been the best part of my practice to date.
Eric, I want to ask you, one of the things that really drew me to you was this house visit thing and just kind of that philosophy you just explained. Um, I shared with you, this last year I helped about 30 families in probate as a real estate broker. And the number one thing that I hear from my clients is they are not happy with their attorney. No offense to my attorney friends out there, because this podcast is really like trying to get a lot of attorneys on here. But it is the number one complaint I have. And it usually revolves around communication. They feel that it's hard to get answers from them. I don't know, because I'm not approaching, I'm not my interactions with the attorneys is usually when there's a real estate problem and I need to, make sure of something before we do something. Okay. Before we make a mistake or something. So but usually they're just like, Jeremy, I can't get an answer from my attorney, or like they're just talking to a paralegal and like they can't, like they want to talk to the attorney and really kind of get an answer. What do you feel like? I know, I mean, obviously I know law is very collegial, but like, what's your take on that?
It's complicated. I think it's a combination of a few things. So, I try to pick up my phone when I can pick up my phone, which is admittedly nowhere near as often as I'd like to be able to do it. I mean, I could be meeting with a client, I could be in court, I could be driving somewhere, but I get a lot of people that are surprised when they ask for Mr. Grogan and I say speaking. And it never gets old. I mean, there's a little bit of a homespun factor to it for sure, I think. But I think that's actually based on what I was reading, and this was a little while ago, that was the number one complaint against lawyers in the Texas bar is my lawyer doesn't answer my phone calls, my lawyer doesn't answer my emails, I have no idea what's going on. I think the best way to combat that from the attorney side is to just try to set expectations and timelines as best you can from the outset of an engagement. I handle probates that are very, very straightforward, where everybody agrees and, maybe there's a hearing or two and we're pushing paper. And I handle some very hotly contested probates where nobody agrees and everything's a battle and everything in between, really. But if the client understands, like, this is, these are our expectations from the outset. This is kind of the timeline. I'm going to update you as regularly as I can. If you have questions, ask. But especially with some of the more complicated probate estates, like there may be a few weeks where you hear nothing from me. And I explain this to clients from the outset is if you hear nothing from me, that means there's really nothing to report. If I'm getting back to you, there's a development or I have a question for you or something's going on. And I think setting those expectations from the outset really it puts clients at ease to understand that you're working for them, you're on the file, you're attentive to what's going on, but I'm also not going to reach out to you for every little detail if it doesn't require doing that. But if there is a development, 12 hours, 24 hours at the most, I'm going to get back to you and update you.
Yeah. I think because you visit your clients in person and you have I sense that you develop a very strong connection with your client from the outset. So just when you establish that level of trust, very similar to what I do, when I have that trust with my client, it can be quiet for a while and they're going to be okay with it, right? So that trust factor is very important. I get a feeling that you develop that very quickly in the relationship.
It's very important. I mean, I wouldn't want to hire an attorney personally that I didn't trust. You have to have, that's a foundation of your relationship. Because this is so complicated, and let's face it, lawyers are not inexpensive to hire or inexpensive to maintain. In a lot of ways, as an attorney, and this is my perspective, it may not be the perspective of all attorneys, but I like to prove my value, and when I invoice you for something, you're going to see pretty clearly, this is all of the work that I did on your file, itemized. I've not fallen asleep at the wheel. And if I need to call you, you see it right there. I called you then, I emailed you then. But that trust part is especially important, I think, in practice areas like probate and estate planning, because it is very, very personal. This is your life. This is your family. These are your loved ones. It's a little bit different than doing, say, like commercial litigation or something like that, where they're just businesses suing each other. This kind of stuff hits home, and it hits home really hard.
I just really, really love your approach so much. And I really mean that. I want to go now into some more specific probate topics. And our listeners are mainly just the general public, just people who are probably going through probate, people I'm talking with about real estate in probate. So let's go through some of these together. For someone who has just lost a loved one and is dealing with property and assets, what exactly is probate? Can you explain it in simple terms?
I like to think I'm pretty good at boiling down the legalese into everyday English, but I'll let the audience be the judge of that. Probate mainly exists. It's the process by which we use to transfer property and assets out of a deceased person's name and into somebody else's. And that is the whole reason we do it, is because after you pass away, unless you've planned in certain ways, property and assets don't automatically transfer to your loved ones. Probate is really a function of either having not planned at all or just not having planned to avoid probate.
One of the things I've really learned in my work as I've niched down into the probate space is it's made me appreciate having a will, having a trust. Probate is just a terrible process. Like if you can avoid it, you want to avoid it, folks. And there's some things that people can do, but I think it's kind of like life insurance. We don't really think about it until we need it, and then it's too late. Would you agree with that, by the way, Eric?
I mean, probate, at least in my experience, probate can be unbelievably awful, and it can be fairly straightforward. It is just so fact dependent, but I shouldn't say almost. I don't think anybody has ever hired me to probate an estate or a will and has been happy to do it. It is a time consuming process. It does have a cost, and it can be tedious. So if you can plan to avoid it, all the better. But it's one of those things that, in some instances, it's a requirement and it's necessary, but nobody's ever excited to do it.
Yeah. Yeah. Going into probate a little bit more deeply, could you explain to us the difference between independent executor, dependent executor, independent administration, dependent administration?
Absolutely. And that is a pretty big line that is drawn in a lot of administrations. So generally speaking, your default in a probate administration is dependent, meaning you need to prove that an independent administration can be opened. Independent administrations are typically awarded when there is a will and somebody is named as an independent executor, and nobody is going to challenge that person's application as independent executor. People do challenge. That does happen. As far as an administration goes, so one of the things that I get a lot, as far as questions go for probate, is what is the difference between an administrator and an executor? And really, the difference between an administrator and an executor is just, is there a will or is there no will? So you can be an executor if and only if there is a will that exists. If there is no will and you have to probate an estate, then you are an administrator. And if you're an administrator, the same rules apply. The default is it's going to be a dependent administration unless everybody who inherits from the estate agrees that someone should serve independently.
What do you see on average happening? What's more common?
When there is a will, it is most common that the person who is named as independent executor does actually qualify and serve as the independent executor. I haven't had that many challenges, at least to date, to named executors. Administrations, though, are entirely different. Sometimes I will have families that will get together and they are fine with a certain person serving. Everyone will sign a waiver. will open an independent administration. Sometimes nobody can agree on who should serve, and we get into a nice little battle. The court will name an independent or a third party administrator, usually another attorney or an accountant or someone else who can otherwise qualify, because nobody agrees on who should serve and everybody's just fighting everybody. That is much less common. But what I will tell you is mixed families, two people who've been married, have children from previous marriages, whether they have children inside that marriage or not, you're going to have a lot more of those kinds of issues because people just don't trust each other.
Yeah. As it relates to real estate, is there a difference with how real property is handled in an, independent, dependent administrator? How are the real estate assets treated differently in these scenarios?
So, in an independent administration, once you qualify and you're named as an executor or an independent administrator, you can generally sell or convey real property without seeking permission from the court. However, when you are dependent, it is a court supervised administration. So you need to file an application and get the court's permission to sell or convey property to a third party.
When the court's involved with the selling of real estate, walk us through what is generally required by the court. What's the court looking for? What do they need from the real estate agent? What do they need from the people that are administering the estate?
In my experience, it's wildly different depending upon the age of the heirs. So if there are heirs that are minors, I think that an application to sell real property is much more heavily scrutinized. When there are not minor heirs, I think the scrutiny level is much less. But they both still involve filing an application to sell the property and getting a court order essentially giving you permission to sell the property. It is generally not a very time-consuming process once someone has been named, but it's still an extra hurdle that you need to get over and across once you've been named as a dependent executor or a dependent administrator. As far as what's required on the real estate side, once there's a signed court order, you have authority to be able to convey the property. There may need to be estimates, appraisals of that real estate as part of the application to make sure that nobody's being shortchanged on an inheritance.
In your experience of dealing with your clients, what are some of the issues or questions or challenges or problems that have come up with real estate, in this situation?
Quite a few, really. And I'll start with some of the biggest ones that I see on a regular basis. I'll just give you a hypothetical that is pretty common. I'll have someone who will pass away, and we need to open a probate administration to not just deal with assets, but deal with real estate. And it turns out that they had a spouse who passed away previously, and nobody opened an administration and nobody transferred that property. So people have this assumption, and I'm not going to say it's a bad assumption or that it's wrong, but a lot of the people that I speak to, at least in my practice, just kind of assume that when two people are married and one spouse dies, well, then all the property just magically goes to the other spouse. And that's not how it works. And a lot of people are really surprised to learn that it's not just, waving a magic wand, that all the property went from spouse A to spouse B. So that's something I see quite a bit. Sometimes I'll see it too, where somebody passes away and they own real estate and maybe they're single, but there's an issue in the property chain. Maybe they inherited that property or a portion of that property from their parents, but their parents' estate wasn't resolved completely, so they don't have clean title to be able to sell it. So sometimes there's even more work to do than what people anticipate.
I've been involved with tracking people down. So I totally understand. I was kind of thinking about something as you were talking. When I was a kind of baby real estate agent, I wasn't really that knowledgeable about real estate at that time, and definitely not knowledgeable about these matters. What you said really struck a chord with me, because I remember going to someone's house and they had a spouse that died, that passed away, and then exactly the situation. It's like I find out later, wait, no, there's some work here that needs to be done, and they don't realize that because they just assume that, oh no, it was my spouse, it should be fine, right? I can sell this property. That's a common misconception among just the general public, but also real estate agents that really need to know this, because it's not uncommon for a real estate agent to go to someone's house, and this situation is quite common actually. And if you don't know what to look for or what to ask for, you could have a problem, right? You might try to you have a listing agreement, but you can't actually sell the property. Which leads me to, what do you think would be like maybe some questions or like a checklist for real estate agents to ask when they kind of detect that there's an issue like this?
The first thing for me is just to ask as many questions as you possibly can of the person who thinks they own the property and wants to list the property, making sure that you have a good relationship with the title company that can just do a brief title chain search to make sure that everything lines up. And, at least in my practice, I very, very regularly hire a private investigator. I have one at the ready, whether I'm tracking somebody down or I'm trying to find some information that's not otherwise accessible online. That is huge. And it's especially important too I can't hammer this point enough, especially with mixed families that have children from prior marriages. People have a very poor concept of how that property transfers under the estates code when there is no will or no trust. They think they own a lot of things that they really kind of don't. One of the hardest things about that is, and I tell clients this on a very regular basis, I practice the law. I did not draft the estates code. I did not vote to pass it. It's okay not to like it, but if you don't do planning prior to passing away or something happening, then the estates code is what you're stuck with, and it is what it is.
I want to switch gears a little bit. I want to ask about affidavits of heirship. This is something that comes up frequently with the clients I have. They might read about it. They're looking for ways to to sell real estate, avoiding probate. Can you walk us through through what affidavits of heirship is, when it can be done? Can it be done while while the probate process is going? In other words, like, can you file for probate and then maybe do affidavits of heirship to kind of fast track the process of selling the real estate? Walk us through that.
Affidavits of heirship are a fantastic option if and only if real estate is the only component of the estate. So I'll have people who will call me and they will want to do affidavits of heirship, but then maybe there's some bank accounts or there's a retirement account or there's assets otherwise that affidavits of heirship do not control. So I will draft affidavits of heirship for clients when I know for certain and I double, triple check it. Listen, there is no other asset that needs to be probated, then this is appropriate. One of the checklists on a good affidavit of heirship is more or less swearing in that affidavit that there is no probate administration that's open. There is no requirement to probate the estate because all we have is an interest in real property and that's it. So generally speaking, it's one or the other.
Got it. Can you also tell us a little bit about muniment of title? What is that? How does that work? What does it mean?
Muniments of title it's essentially applying to probate a will without opening a formal administration. And it's fairly common for married couples when somebody loses a spouse, or maybe when someone loses a parent and that person who lost their parent has a complete understanding of that parent's estate, knows there are no debts, knows everything can essentially be transferred under a muniment of title. Muniments of title are great when you know for sure that there are no debts to the estate and that there isn't a Medicaid issue, because you cannot use a muniment of title if there's a Medicaid clawback. So if your spouse or your mom or your dad or whoever has passed away qualified for and received Medicaid benefits, I think it's after 2005, anytime after 2005, then you can't use a muniment of title as an option.
Okay. Okay. I want to get into some real world scenarios, kind of like a case study kind of discussion. And I want to start with, can you share a situation where having proper legal guidance saved an executor from a very serious problem? Maybe you can give us a couple of these scenarios.
I think, at least in my practice, I get a lot of people who, and this kind of harkens back to something I had said a little bit earlier. Nobody wants to open a probate administration. Nobody wants to pay a lawyer to do that. People, and this is not a criticism because I do it myself in other avenues in my life, seek the avenue of least resistance, something that costs less than something else. I mean, the world is an expensive place, let's face it. But I'll have a lot of people who will want to use small estate affidavits, which is another mechanism you can use under Texas law But I very strongly discourage most people who call me to try to do that, because you have to have a concept of all of the debts that the estate has. And most people, really most people, don't have a full understanding of the debt that an estate can have. And they'll want to push through small estate affidavits. And then if you have a creditor or a credit claim that comes through on the other side, you can have an issue. So there's been a few instances where I've advised people to open administrations, because I didn't feel like, at least in my opinion, that they had a good enough understanding of the estate debts. And sure enough, as soon as we open an administration, all these creditor claims come through, and it's me reassuring the client of, this could have gone very differently and could have been a lot harder if you tried to push through the small estate affidavit, because we'd be right back where we are now, just with more expenses and more time getting to the same place. So that's an example of it. I have defended clients in the past that have been named as administrators or as executors or as trustees of trusts from litigation, from beneficiaries. It's not incredibly common, but it does occur. I don't think there is a good reason not to have legal counsel in that kind of situation, because as a fiduciary, even if you're just a trustee of your parents' trust, there's a lot of responsibility that comes with that. And if you're being challenged by other beneficiaries, missteps can be very, very costly.
That's very interesting. What are some of the things that cause beneficiaries to come out of the woodwork and start challenging?
So I have not yet dealt with anybody challenging the actual document, meaning that for some reason the document is invalid or voidable, or there's some kind of issue with the language in it. Almost always it's essentially a personal attack on the person serving, meaning that they're breaching their duty, either as an executor or administrator or a trustee, because they're not following the terms of the document, or they're doing something that's self-serving, or they're mishandling funds that belong to an estate or belong to a trust. That's mainly the crux of challenges that I've defended from. And I wouldn't say it's common. It's really not, at least in my practice. But when it occurs, it's usually sisters, brothers that they just don't get along, and they didn't get along before somebody passed away. They're not going to get along now. And somebody wants to make someone else's life very, very hard.
Yeah, yeah. And it's very expensive for both parties, right?
It's expensive to defend. And a lot of times it has nothing to do with money. It has everything to do with a personal animus, at least in my opinion and in my experience.
It's interesting. I want to actually go a little bit off my plan here and talk about something. You mentioned fiduciary, and this is interesting because as a real estate broker, we're a fiduciary to our clients. We're held to a very high standard with how we treat the business affairs of our clients with regard to real estate transaction. And something that's kind of interesting, I don't know if you had a chance to go to my website and kind of go through some of them. Hopefully it passed the attorney scrutiny.
It does.
But, one of the interesting approaches that I have is that one of the things I noticed right away when I really started to get into helping people in probate is once that paperwork is filed, they're getting hammered from every direction. I mean, they are getting mail, phone calls, texts with regard to real estate. I'm only talking about the real estate part because there may be other parts I'm not aware of. But in terms of real estate, all the real estate investors from across the United States and even internationally, believe it or not, they're calling, they're sending letters. Okay, I'm sending letters. Here's what I'm kind of getting at. When the paperwork is filed and people are reaching out to the executor or the personal representative at this point, right? They're not appointed yet. They're pitching basically, hey, look, I can offer you a cash offer. This is quick. You can sell it as is. Don't worry about anything. And you don't have to pay any commissions, right? That's a big selling point. But the reality, and I'm sharing this because I know other attorneys are because I'm going to have, of course, we love you. We want you to be an exclusive guest. And I would like to, if you have time at some point, I'd love to have you back on, because Eric, I really like you personally. So I'd love to have you back on. Maybe we can have, even a third person on, we can have a three-way conversation.
It'd be a pleasure.
Thank you. I appreciate that. But what I'm getting at here is that I'm not sure exactly how all of the personal representatives take this communication, but I want to share a little bit about how I see it as a real estate broker. I'm kind of hardwired from a business point of view to really help my client get the most amount of money and the best terms for the client. That's just what we do. That's the business model. That's what it's about. And I think most real estate agents would agree. But here's the thing though. Here's what's kind of interesting. So if I just take the investor side, right? They have no duty to the personal representative. We want people to be nice and honest, okay? But they don't have the same kind of obligation I have to be fair and honest to the public, right? So they're just doing their thing and they're just trying to get it at bottom dollar, right? Now they say no commissions, all of this, but the reality is that those offers typically are like 60%, 70% below market value. And the general public generally knows very little about real estate. That's something I've learned as a real estate broker. I started real estate in 2017. Admittedly, I didn't know a lot about real estate when I started. I mean, I'd like to think I'm an expert now after so many years and now being a broker. But the general public, I mean, I just kind of think like, what did I know when I started real estate? I mean, it was so little. I mean, the general public probably knows even less. Granted, there are some sophisticated people out there, but it's not the majority in my opinion. So they get all in love with this no commission idea, but it's like I tell them, I go, look, I mean, even after paying my commission, you're still going to be making way, way more money. But also, here's the other part that I think is important, and I'd like you to opine on this, is that the executor and administrator has a fiduciary duty to the estate, to the heirs, right? They have really kind of this sacred responsibility. And it's my view, and I actually believe in this very strongly, that unless you have a house on the open market to allow all buyers and sellers the opportunity to see that property for sale and then allow it to command its value, you really haven't done your job. That's how I see it. Maybe you would disagree. I'm very open to your opinion on this. I think there are some situations where the property might be in really bad shape, disrepair. But as a real estate broker, I've sold everything. I've sold houses where I could see the stars at night from inside the house, and I was able to get them more money than an investor would offer them. So one of the things I tell people I'm talking to is that they have these offers and they think it's special. They think that there's something special about their property because they got this offer from someone, and they don't realize a lot of times that these are just like literal like offer mills. There's actually people. They're in the Philippines. They're in other countries, and they're trained to make these offers, and they're just sending them out now with AI. There's automated systems sending these out. So there's nothing special about a cash offer at all. And by the way, this is one other thing, Eric, is that a lot of times these investors, they're actually not the end buyer. They're a wholesaler. They're just basically putting them under contract, and then they're trying to assign that contract to someone else. And a lot of times they don't have the buyer lined up. They're wasting time, right? Where they could have got the property on the market and sold in a fraction of the time. So anyway, I'm just kind of sharing a little bit off the cuff here, but what do you think about some of that?
A lot of it comes down to patience and sophistication. And I'll speak a little bit on patience first. Some people are really in a hurry to liquidate what they get, whether it's because for some financial reason they need the money and they need the money now, or they just don't have the patience for something to sit on the market. And I will offer a completely unqualified opinion on the current market. I just noticed there's a lot of properties that are sitting a little bit more than they were a few years ago. And I think some people don't have the patience to let it sit. The sophistication part of it comes in where they may not fully realize exactly how much money they're walking away from. A big part of being a personal representative, whether it's for a trust or a will or for an administration where there is no trust or will, things are a lot easier when everybody agrees. So if everybody's in a situation where okay, we got some offer 60, 70 cents on the dollar, and we really need to get rid of it. You're not breaching a fiduciary duty so long as everybody agrees and everybody knows and understands the implications. That's not to say it's the savvy or smart thing to do in that particular instance, but you can still do it. I think people's patience and their level of sophistication with the real estate market definitely varies from person to person. But I think that's also consumerism too. Some people will never buy something at full price, and some people will never sell anything unless it's for top dollar. But as long as you're advising and making sure that, whether it be your client or my client knows the implications of what they're doing and generally what the landscape is. I've seen clients do things that I wouldn't do in a million years, but that's what they wanted to do and everybody agreed it is what it is. And I've seen clients make savvier decisions too. So, at some point we are advisors, we are giving advice, but they don't have to take it, right?
That's right. Absolutely. You mentioned the market, and that's interesting. And you're correct. The market is in the greater Austin area and also San Antonio, where I practice real estate. It has slowed down considerably. Actually, values have gone down roughly 20 to 25% since May of 2022. So it is a different market. Here's the interesting thing, Eric. It is true that many properties on the market today are sitting for longer, but here's what's interesting. Houses that are priced correctly still sell in a short amount of time. Because the reason why the days on market is increasing or has been increasing for this is for the past 3 years, and why it's really gotten up there is I'm actually working with a buyer right now, a past client, and most of the houses we're looking at are like 100 days on market. And let me tell you, that is extremely painful for a seller, but also a real estate agent. I mean, that's tough. But here's the thing, like I said, properly priced and positioned property, no matter the condition, and I have that on my website, and that's true. No matter the condition, will sell relatively quickly, even in this market. The problem is that people saw what their neighbor sold their house for a few years ago, or even a year ago. We're actually down about 6-7% this year over year. 7% on 400,000, 500,000. I mean, that's a lot of money, right? That's tens of thousands of dollars. So, there's that kind of price expectation that's not aligned with where the market is, which is why I believe it's very important to work with a competent real estate professional, because it's not just about trying to figure out what that value is, at what it's going to sell for in a reasonable amount of time. But it's also being able to explain it to the client, to be able to present information and present the argument that gets the client to see why we should price a certain way, whether it's pricing it at what we think it should sell for, or whether we use pricing strategies that cause more demand to occur. Having that pricing presentation, which is a sales process, is really important. And a lot of agents don't have that. This is one of the reasons why I really like working in the probate space, is because, we have people that they have an asset, they need to sell it. Most people want to get the most money for it. And they'll say things like what you just mentioned, which is correct, which is basically, hey, look, we're worried because, these houses are sitting for a long time. Maybe the personal representative is like paying the mortgage to kind of keep it going or something. So, it's scary. And so they'll be tempted to take these quote unquote cash. I don't like to call them cash offers, but I like to call them off market cash offers, because that's really what it is. And they think that is the way to go. And I'm like, no, there's this other way. Let me show you this other way where I can actually do it almost as fast, and you'll do better money wise. And that's what I'm very passionate about with my clients, Eric, because I'm kind of the anti-investor in a way, because while that is a legitimate choice if they so choose, it's I mean, it is literally, honestly, if I could just say it just the way I think of it, it's literally just going down the toilet. You're literally just pouring equity down the toilet. It's very hard to see it as someone who's in real estate. It's very hard to see it, especially when I know they can do it just as quickly and profitably. I want to run something by you. You're an attorney. I'm just kind of curious how an attorney mind thinks about this. So one of the decisions I've made in my business, now I may change this at some point, but it's the decision I've made, and that is that some agents, they kind of try to wear two hats. They're agents that invest in real estate, and they go in, and what they really want to do is they want to buy the property. Oh yeah, I can list it, but what they really want to do is they want to buy it. And so they're going in, and here's what's interesting. Here's what I've found. And this is kind of my philosophy. If I present to you as a real estate broker and I'm trying to help you, in other words, I'm here to help you. I'm here to help you with the real estate part of probate. I'm not an attorney. I can't help you with that, but you have this asset. I'm an expert in real estate. I'm an expert in real estate sales, and I can help you with this. I can help you get a great result. Okay. If I am marketing that, but then I have this kind of like below the table, kind of like, okay, but actually I want to buy it, or I've got my little investors here on the side that I can sell it to. I don't like that. A lot of people a lot of real estate agents in the probate space are doing that. If you go on YouTube and you just do a little bit of research, it's all over YouTube. It's amazingly, it's all over YouTube. And I've kind of taken the position, Eric. I'm like, okay, if I market to you and I am talking to you and I'm coming at it from a position of, hey, I want to serve you, I want to help you. Yes, I'm a business. I have to make money. I have to keep the lights on here at Kritt Real Estate. I got to put food on the table for my family. I'll just like you. But I want to do it in a way that, that is consistent with my messaging, right? So I'm here to help you and I am here to help you. I'm not here to try to get my little private deal because I have access because I was able to kind of get myself in there. What do you think about that? It's interesting because the argument that's used is that, well, not everyone wants to list it for sale. And that's true. That's true. But I've kind of taken the approach, at least in my businesses, if I approach you as a real estate broker, I'm a real estate broker. If I approach you as a real estate investor, then I approach you as a real estate investor, right? But to do kind of like, you know what I mean, to kind of slip the other side in, I just view it as a little bit, I don't know. It doesn't sit well with me. What do you think about that?
For me, it erodes at trust. If I'm coming at you from one perspective, but I have my own, ulterior motive otherwise, whether and if it's apparent, maybe less so if you mention that from the very outside of an engagement, but I just don't like the idea of trying to profit off of my clients beyond the service that I offer. And if some people want to do that, and if it's quote unquote legal and it's quote unquote ethical based on whatever prevailing standards there are, I got to look at myself in the mirror at the end of the day, and I wouldn't feel great about it if that's how I was running my business. So for me, that's uncomfortable. And I'll very much fall short and stop short of calling it, predatory or deceptive. But I think you could quite easily veer into those avenues if that's your business model and that's your MO. But no, I'm very much on the same page as you. Client service is client service. It should only service me to the extent that I've done something to earn it. I'm not interested in profiteering off of my clients.
Yeah. It's very interesting in real estate because, it's not illegal to do what I just mentioned, right? I mean, you can do it. But, from my perspective, it's one of those things where you're dealing with people, and at least with my clients, they're a lot of times there's a lot of grief, emotion. They're looking for people to trust. You as an attorney, of course, me as obviously very different things, but me as a real estate broker, people trust once you're dealing with people in real estate, I mean, you're learning everything just like you do. You're learning about all the inside, baseball of what's going on with their situation. You're in a very privileged place and they're disclosing a lot to you. You're getting a lot of insider information that you ordinarily wouldn't get. And they're giving that information because they want help, right? For you to help them, they have to share that. And so I personally take that very seriously. I view that as a sacred trust. And it's something that bothers me in the real estate industry. That's why I bring it up, especially in the probate space. And so that's just my approach. And I was just kind of curious what you thought about that.
Yeah, I mean, are you really serving the client if you're trying to profit from the client? I mean, as you say, I have no question that it's legal and it probably doesn't violate some codified ethical rules, but it doesn't necessarily mean it's the right thing to do. And I do think that it erodes at any trust you can build.
Yeah, and I think it's like, if I want to do a real estate investing with, let's say, the probate kind of group, then I think if you just, from the outset, if that's your presentation to them, then all right, fine, go for it.
Absolutely.
But if you're going as a real estate broker, but then I've got this, I've got that, it's like, from my perspective, it's like, well, what are we doing here? Yeah. And by the way, that's very controversial. Other real estate agents will hear this and they will not like what I say, but that is how I feel about it. And I don't care because I run Kritt Real Estate. I own this company, so I can do what I want here. All right. So I want to just switch gears a little bit, Eric. We're kind of winding down a little bit here, but I want to talk a little bit about avoiding probate planning. What can we do to make this easier when someone passes away and they have assets? Tell me a little bit. How can we avoid probate? What are questions people should be asking? What are the services that they should be considering? How can they approach you for some of this?
It's funny. I get a lot of people who engage with me, and it's a lot of times it's the same inquiry. It's, I want to put together a very simple will and I want to avoid, and that's impossible because wills are probated. So if you create a very simple will, you're not avoiding probate. I think that there is a dearth, an absolute dearth of good information out there. And I tell my clients and even prospective clients the same thing, that I can jump on Google or ChatGPT or anywhere else. I can look up the same stuff you're looking up. The difference is I practice in this space all day, every day, and you do not. So you should be consulting with somebody who does, whether it's me or whether it's somebody else. I believe personally and professionally that at an absolute minimum, everybody should have a will at a minimum, because having to probate an estate without a will is objectively terrible. And it's not terrible necessarily because probate's terrible. It's just terrible because it's expensive and it takes a lot of time. And people are a lot of things, but they're not patient. And I get that. So at a minimum, put a will in place. If you want to be more sophisticated, look into trusts and other vehicles that are similar to that. But what you should do is you should find somebody that you trust or you think that you can trust, be honest, and ask as many questions as you can possibly ask, because this stuff is confusing. And there's the stuff you're reading about online doesn't always apply to you, doesn't always apply to the estate that you think you have. And sometimes that information is also just flat out incorrect or it's dated. So find somebody, in my opinion, and it's worth what it's worth. The smartest people I know delegate the things they don't know. And I try to do the same in my personal life. I'm not walking around messing with my own electricity or redoing my own roof. It's not my space. Find somebody whose space it is. And if you can trust that person or that firm, work with them and just ask as many questions as you possibly can. Because a big part of estate planning too is learning. This stuff doesn't work the way you think it works. And there's all sorts of options that you have that you might not think that you have. Just ask questions.
Yeah, yeah. Can you tell me a little bit about, I know this is a very big topic, but just briefly, what is a trust?
A trust is essentially an entity. It's not you, it's not somebody else, it's its own legal entity that essentially, theoretically, if done properly, will own all of your assets when you pass away. And it will distribute all of your assets to the beneficiaries that you list without needing to go through the probate process.
Got it. So if I want to avoid probate, I get a trust.
That is one great way to do it. Yes. And an unfortunate tag on to that answer is there are so many different kinds of trusts and so many different ways to do it, which goes back to my previous response of find somebody you trust and ask questions, because there's far more than one way to do the same thing. And what works for some people may not work for others.
Yeah, I love that. I love that. It just really shows the value of talking to an expert and really staying to your lane. That's, great real estate attorney told me a good way to stay out of trouble is to stay in your lane. And that's what I try to do, and yeah, tell us, Eric, how can people get in touch with you? They've been hearing this podcast. They like what they're hearing. How do they make contact?
Yeah. So it's my website has essentially like not a chat applet, but a place where you can leave a message and a phone number and an email. And I tend to be incredibly responsive to that. You can also just call my firm as well if you'd like, and I might pick up. Depends on what I'm doing at that particular time. But if I don't, somebody will schedule you a day and a time to jump on a phone call with me. I do not charge for phone calls and consultations. I know a lot of lawyers do. Maybe I am a little too homespun, old fashioned, small town, if that's what you want to call me, but I don't like charging people for conversations if I'm not even sure I can help you. But that's the best way to do it. And, I try to respond to all my inquiries within 24 hours, and maybe I can help you, maybe I can't, but at a very minimum, I can answer some of your questions. And if I can help you, I can steer you in the right direction.
That's awesome. Let me ask you one last question before we go. If you could give one piece of advice to someone who just became an executor or administrator of a probate estate, what would that be?
Slow down.
Okay.
Don't make any decisions or distribute anything or do anything until you're 1,000% sure that what you're doing is what's in the best interest of the estate and doesn't implicate any liability for you.
Okay.
That's what I would do, because people have a tendency, and myself included, in other avenues. Like, okay, I got a checklist. I got to do this, 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 and this, and that's great. But as far as being a representative of an estate or of a trust, just be careful. Double and triple check. Make sure you know exactly what you're doing and that you've got your bases covered. That's all. And it's really not as difficult a job as it sounds if you take it slow and you ask questions. If you're an administrator or an executor, you should be represented by an attorney, and you should be asking that attorney all of these questions before you do anything. If you're a trustee of a trust, that's a little bit different, because you're not really required to be represented by counsel. If you're not in a closely held familial situation, checking in with an attorney is smart.
Awesome. Awesome. I want to thank you very much for joining us on this podcast. You really provided a lot of valuable information, and I want to really thank you. I hope I can have you on again in the future. I'm just curious, is there any question you have for me? Anything you want to ask a real estate broker?
At this time, no, because your website was so good. I was able to. No, seriously, and it's a genuine compliment. You've put your business together very well, and that was one of the reasons why I was so happy to join you today.
Awesome.
It's a
Thank you
pleasure to know
so
you and
much.
a pleasure to work with you.
Thank you. Thank you so much. Thank you so much for joining us.
Awesome. Well, it's a pleasure. Thank you so much for having me.